My name is John Whyte. Currently I hold the Ariel Sallows Chair in Human Rights at the College of Law at the University of Saskatchewan, but I have been a law teacher and a public servant for 4 decades in Ontario and Saskatchewan and some other places in Canada and the world. But as I say, right now I'm at the University of Saskatchewan. Section 1 got judicial attention very early, of course, because rights have to be assessed through the prism of Section 1. And they got their fullest consideration in a very famous case called Oakes. And the general purport of the Oakes test was to create a very stringent set of standards before legislatures could limit rights. And so at the outset, there were some surprising results. Seemingly good legislative projects, say, around advertising smoking, were nevertheless struck down because they didn't satisfy the Oakes test or the Section 1 test, proving that the limitation on rights was socially valuable, that the government was not able to prove that. But over the years, Section 1, in my view, has been applied more and more loosely, and it does not have the same, does not get the same rigorous analysis as it got in the early years. I mean, in the most recent, I can think of 2 very recent cases, one called Patriation Reference and another one called Thatcher, in which the Section 1 justification for the loss of rights is just assumed without any serious analysis at all. Again, there's a lot of case law, and in any given year there'll be some that is rigorous and some that is not rigorous, and it's hard to generalize. But generally speaking, I think that Section 1 is serving maybe double duty or duty and a half on behalf of legislative authority over the constitutional rights of individuals.